of their home. We will also look at COVID-19 impacts on tax residency, implications for real estate and the property market, and tenancy rights, which may affect those of you holding residential investment properties in Australia right now. Again, thank you to our AustCham Finance, Legal and Tax Committee, and thanks for our sponsor, CPA Australia. Our moderator for today's session is Gavin Ord, Manager of Business and Investment Policy at CPA Australia. Gavin Ord is the policy lead for Asia for CPA Australia and has the responsibility of development of policy, research and advocacy on issues regarding business and the economy, including small to medium-sized enterprises, taxation and regulation in Australia and Asia. And he's been a terrific partner with AustCham Hong Kong in supporting our advocacy efforts with Treasury on a number of these key areas. I will now turn to our expert panelists from ShineWing, who we have Daniel Minahan, partner and head of business and private client advisory at ShineWing. Daniel works with a wide range of clients from small individuals to large private family groups, advising on issues diverse such as cash flow, debt structuring, personal protection, and retirement planning for individuals through to asset allocation and portfolio construction and investment selection for investors small and large. And we also have Justin Battichotto, Associate Director of Tax at ShineWing. Justin is a specialist in global mobility and employment taxes with nearly 20 years experience across Australia and Singapore, including global mobility tax services with Big Four firms. Justin specializes in advising on a range of global expatriate services from taxation, social security, and superannuation planning to issues related to tax residency status, fringe benefits, tax, and also payroll tax. And I will now hand over to Gavin. Thank you all.
Hello, and welcome everyone to today's webinar on changes to Australian tax rules. And there have been many. Today we're joined by not just members of AustCham in Hong Kong, but also Philippines, Taiwan, and Korea. So please, I extend a welcome to all those people. So we have a very large number of participants today. I encourage you to ask your questions through the chat box. First of all, I'll hand over to Daniel, who'll talk a bit about ShineWing, and then we go into the meat of the presentation, which is about tax residency, the capital gains tax changes for main residence exemption, a property market update, and some of the state-based land tax changes that have happened in recent months because of COVID-19. I'll now pass over to Daniel to introduce ShineWing.
Great, thanks Gavin, and thanks everyone for attending. Obviously this particular topic has been in the news for any number of different months now. And so, you know, the overlay of COVID-19 has certainly brought some more spotlight, I guess, a larger spotlight to some of the issues and difficulties that many of you are facing as non-residents. So a very quick introduction to ShineWing for those of you who don't know us. Or who do, but maybe don't know a lot about us. ShineWing is the fastest growing international network in the world, ranked 19th globally in terms of accounting firms. Our headquarters is in Hong Kong. In Australia, we have some 300 staff in Brisbane, Sydney, Melbourne. We also have specific Australian staff located in Hong Kong, and Shanghai. You know, we focus on advising clients, small and large, businesses, small and large, and have a particular focus on Australian businesses looking to move into the Chinese market, assisting Chinese businesses moving back into the Australian market, and investors are going both ways as well. So today there's 4 main topics that we're going to cover. Justin will kick off talking about residency and a bit more of an update on the capital gains tax situation. I'll then pick up from there, give you some insights into the property market, and we'll also talk a little bit about some of the land tax concessions that are available to landlords on a state-by-state basis. So I might now switch over to you, Justin, to kick off on the residency discussion.
Thanks, Daniel, and good afternoon, everyone. My name's Justin Vettichotto, and I'm an Associate Director in the Tax Division at ShineWing Australia. And today I'm going to firstly touch on tax residency and the issues that individuals are having around the COVID-19 pandemic. But before I jump into some of those issues, it's firstly important to understand, well, why is tax residency so important? And really it underlines two key factors. One is, when determining an individual's assessable income in Australia, we need to understand an individual's tax residency status, as well as the source of their income and assets. Because where someone is deemed to be a tax resident of Australia, they are taxed on worldwide income, while individuals that are non-residents of Australia are only taxed on Australian-sourced income. So for Australians that are living permanently abroad, especially those in low or no taxing jurisdictions, type of income such as employment income becomes critical in determining whether they are a resident or a non-resident for tax purposes. There we go. So there are a number of tests in determining whether someone is a tax resident of Australia or not. And there's a little bit of a misunderstanding within the community around an individual being present in Australia for less than 183 days and therefore automatically being a non-resident of Australia for tax purposes. That's not necessarily the case. And we really need to look at the tests, and firstly the primary test being whether an individual ordinarily resides in Australia or overseas. And there's a number of key factors that we look at when determining where someone ordinarily resides. And that really looks at the individual's behaviour, their intention or the purpose of their presence in that location, where their family ties are, where their business or employment connections are, the period that they're going to be in that foreign location. We look at the location of their assets and also a lot of their social and living arrangements. And based on that, we can make a determination of where they ordinarily reside. There are also 3 statutory tests that need to be looked at. And they include the domicile test, the 183-day test, and the Commonwealth Superannuation Fund test. So this is what needs to be weighed up when determining whether someone is in fact a non-resident of Australia or a resident of Australia for tax purposes. The Commissioner did release a taxation ruling a number of years ago now that also helped provide additional factors around determining whether someone who leaves Australia temporarily works, so someone that leaves Australia temporarily to work overseas, whether in fact they cease being a tax resident of Australia. So this again looks at the individual's intention, the establishment of a home outside of Australia. So are they staying in hotels or have they signed a long-term lease on a property? What have they done with the home in Australia? So if they own the family home, are they renting that out on the market? Did they dispose of that property? Or is it in fact sitting vacant and actually available to them? So there's a whole range of factors that we look at when analysing an individual's tax residency status. It's also important to note that double tax agreements also do provide some tax protection, and most double tax agreements have tax residency tiebreaker tests that can provide an added level of protection for individuals. It's important to note, as most people probably on this webinar would realise, that Australia does not have a double tax agreement with Hong Kong. So individuals unfortunately cannot look to a double tax agreement to provide an added level of protection. So the COVID-19 crisis has really created a lot of challenges for both employers and individuals. And we're seeing a lot of Australians that are temporarily back in Australia due to COVID-19 and are starting to question, is this going to impact their tax residency status? The ATO has actually been on the front foot and has been providing regular updates to provide some guidance to both employers that have employees that are temporarily back in Australia, as well as individuals who are starting to have concerns around how is this going to impact their tax residency status, as well as their investments in employment income, etc. So the guidance that's been provided to date is really individuals who are ordinarily a foreign tax resident of Australia and who are back temporarily in Australia because of COVID-19 will remain a non-resident of Australia for tax purposes, as long as they usually permanently live overseas and intend to return overseas as soon as they are able to. The ATO have also confirmed that those individuals that are stranded in Australia who continue to work remotely, performing their overseas role in Australia, and continue to earn employment income or paid leave, that income will continue to not be taxed in Australia, as long as it doesn't have an Australian source. One important point to be aware of is that people do need to be aware of the distinction between the ability to return overseas compared with choosing to remain in Australia. So this is something that obviously we're still in the midst of the crisis, but in the coming weeks and months when international travel becomes eases up a little bit, and there is an ability for people to return to their normal location of residence, if individuals do choose to remain in Australia for longer periods of time, how the ATO will view this. And that is something that will become clearer as the following weeks and months progress.
Justin, we've just had a question come in. What is the Commonwealth Super Test?
So the Commonwealth Superannuation Test is if an individual is continuing to participate and contribute into a Commonwealth Superannuation Fund, and there are specific types of Commonwealth Superannuation Funds, and I won't go into that level of detail at this point, but if you are continuing to contribute into those funds whilst living abroad, then in some situations you are unable to break tax residency in Australia. So if you've previously worked for the Commonwealth or still work for the Commonwealth and are contributing to an Australian specific Commonwealth superannuation fund, then in some situations you are unable to break tax residency.
So for most situations, that would be an Australian public servant working in Hong Kong, for example.
So guidance for individuals, the ATO have recently advised in their last publication or update was on the 23rd of April this year, that individuals who are continuing to work remotely and their stay does go beyond three months, that employment income will still remain not accessible in Australia as long as that employment income does not have an Australian source. So generally we would deem that if an individual is continuing to perform their overseas role, that would not be deemed to have an Australian source. However, if an employer has decided that employee, whilst back in Australia, starts working for the Australian business and performing the role that would be expected of an Australian employee, then there may be some risk that employment income now has an Australian source. So really each situation needs to be looked at on a case-by-case basis. It's important to note that double tax agreements often provide an added level of protection when individuals are temporarily working back in Australia. And for those individuals that are temporarily back in Australia because of COVID-19, do have double tax agreements to fall back on, that can provide some tax protection. As we mentioned earlier, Australia unfortunately does not have a double tax agreement with Hong Kong. However, in the most recent ATO update, the ATO have decided to extend that double tax agreement relief to non-DTA countries such as Hong Kong. So that gives some level of assurance to individuals that are ordinarily working in Hong Kong that are back in Australia, that their employment income may still continue to be non-accessible with the ATO extending this concession. We've included some guidance here for employers. So as you can appreciate, there are a number of employers who, for Australian employees, Australian employers who are trying to recruit employees from overseas, they're unable to get their employees physically in Australia to commence the role, as well as some employers have staff that ordinarily work outside of Australia that are temporarily back in Australia. The ATO have advised that foreign employers will not need to register for pay-as-you-go reporting and withholding if they have employees temporarily back in Australia, as long as that period does not breach a 3-month limit and the individual does leave before 30 June. However, this concession is not extended to Australian employers. So Australian employers that ordinarily have staff working for an overseas entity or one of their overseas subsidiaries that is temporarily back in Australia, that they may be creating an FBT or superannuation obligation in Australia. My last point on tax residency is obviously over the last 12 months or 24 months, we have been seeing an increase in audit activity around tax residency. In particular, the ATO focusing on countries of zero tax or low taxing jurisdictions, such as Hong Kong, Singapore, and a lot of the Middle Eastern countries. And the ATO use a whole range of data to determine whether someone is at risk of actually re-establishing residency. So they use AustCham records, so individuals who are regularly transferring funds back to Australia. They use information from the Department of Immigration and looking at individuals that regularly travel back to Australia to really determine, or at least ask the question, is that individual in fact a resident of Australia? And you can appreciate with the Australian top tax rate of 45% plus the Medicare levy of 2%, there can be a substantial difference in amount of tax on the table if the ATO are able to argue that someone is in fact tax resident. The common scenarios that we see are where family remain in Australia, or where family repatriate early from an assignment, but the main taxpayer may remain overseas. And this is common with where children are hitting critical ages of secondary school education. And what that will often result in is that individuals start returning regularly to Australia to visit their family. So if you find that you are in a situation that might not necessarily be clear cut, it's important that you do seek proper tax advice. And because this can afford you some protection or at least understanding of the risks involved in your situation. We thought we would include some information on just rental property deductions. There might be a number of landlords on this webinar that might either be renting out the family home in Australia or have investment properties in Australia. And some of these individuals might have tenants that are unable to meet their rental obligations, or they may have chosen to come to some sort of agreement with the tenant to reduce the rent in order to enable for the tenant to remain in the property. The ATO has confirmed that where this is the case and that the rental income is either significantly reduced or non-existent, but the landlord is continuing to incur normal expenses, but those expenses will still be fully deductible in your tax return. As well as individuals who have worked with their banks and may have looked to defer repayments on loans. The ATO have confirmed that interest deductions will still be deductible as long as the interest continues to accumulate on those loans. As was mentioned earlier, we also wanted to use today as another opportunity to remind people of the changes in law around the main residence capital gains tax exemption. So for those that aren't aware, in December 2019, the bill became law, and effectively the way that the new law is applied, if a main residence was acquired after the 9th of May 2017, then the new law applies immediately. However, any main residence properties that were acquired before the 9th of May 2017, then if we get to a position after 30 June 2020 and an individual disposes of their family home after this date, and they are considered a non-resident of Australia for tax purposes on the date of sale, then there will be full capital gains tax on the disposal of that property and no ability to claim the main residence exemption period. And the new law does not allow for an apportionment for the period that you were living in the property. So we're aware of a number of cases where an individual or a family have treated that property for 15, 20 years as their main residence and might have only moved out of it in the last year or two. If they were to dispose of that property after the 30th of June, whilst a non-resident, there would be full capital gains tax on the growth in that property. And you can appreciate for those that purchase properties, whether it be the late 80s or in the 90s, there would be significant equity within that property. There were minor changes made to the reintroduced bill that included certain life events that if they occurred within the first 6 years of of a property being used for income producing purposes, that the new law may not apply, but these will be in very limited situations. So it's important that individuals are aware of the new law that takes effect for pre-May 2017 properties from 30 June this year. So really, what are the takeaway for individuals? One key point is that the absence rule can still apply. And for those that aren't aware of what the absence rule is, the absence rule allows an individual to rent out the family home for a period of up to 6 years, and that property does not fall into the capital gains tax system. So as long as you've rented the property for less than 6 years and you resume tax residency before the date of sale, then you can still apply the main residence exemption. We also appreciate with the COVID-19 crisis, and for those individuals that are trying to sell the family home before the 30 June deadline, COVID-19 is creating challenges in itself of people being able to sell the property. We know that there was a period of time where auctions were stopping and open inspections were suspended. So we appreciate that there are challenges in selling the property for those that are considering that. However, unfortunately, at this point in time, the Australian government has not provided any indication that they are looking to extend the deadline of 30 June 2020. So the critical takeaway is that if you are thinking of disposing the property, that if you are a non-resident of Australia for tax purposes and you do dispose of it after 30 June 2020, then there will be capital gains tax implications. So it's important that you seek tax advice before such an event. And I just thought I'd end on a quick example. So for a lot of our clients, we see clients that have acquired properties in the early 90s or late 90s. So in this situation, if an individual had purchased a property in 1998 for $700,000 and immediately treated the property as their principal place of residence and lived in the property for 17 years, and then in September 2015, they relocated overseas, and we can use Hong Kong as the example, and then rented the property for 4 or 5 years. If that individual disposes of that property in June 2020, before the 30th of June deadline for $1.8 million, there would be no capital gains tax in Australia. So in this situation, they've rented the property for less than 6 years, so the absence rule applies, and there would be no capital gains tax on the appreciation of value of $1.1 million. If, however, that individual sold the property in July of 2020, then there would be full capital gains tax on the growth in that property. So that is a $1.1 million growth, and at a tax rate of as high as 45%, that could result in a liability of close to $500,000 Australian dollars. Looking at point B, however, if the individual was to hold on to that property, repatriate back to Australia and resume being a tax resident, regardless of whether they move back into the property or not, if they are a tax resident, when they dispose of that property, they can apply the main residence exemption. Now, in that situation, they would have rented the property for slightly greater than 6 years, but there would be a significant exemption that will apply to the growth in that property. So I might now pass over to Daniel, who will take us through a property market update.
Thanks, Justin. I'm assuming my screen's come up. I think it has. Okay, so yeah, we thought we'd walk you through a little bit of an update on the Australian property market and where that currently sits. And rather than doing it in words, well, words on a page at least, I'll step you through a series of charts that hopefully gives you a bit of context as to what's been going on in the market. So from a from a big picture perspective, there were reports, as I've said there, that the Australian property, particularly residential property, was dead and buried. That in fact isn't the case. The three things we do know is that volumes are down, clearance rates are down, and sentiment is definitely down. but capital city values really haven't fallen as sharply as expected. Now, I've put yet at the end of that sentence because we obviously don't have a crystal ball, but you know, capital city markets have shown a little bit of a weaker performance relative to regional markets. So the combined capital cities index was up 0.2% in April compared with, you know, a 0.5% rise in regional markets. But all in all, they have held up reasonably well, at least over the most current months. So I think it's also really important to remember that if you have held a property for any length of time, returns have been strong, you know, since you've held it. So you, other than, as I've said there, Perth and Darwin over in the very short term. So this is, you know, what we often refer to about sort of paper losses. So you always need to take some consideration in absolute returns. And although housing values have generally been slightly positive over the month, the trend has clearly weakened since sort of mid to late March, when the social distancing policies were implemented and consumer sentiment started to head down. The view, I guess, of the market is that the largest cities have a higher level of downside, particularly Sydney and Melbourne. Probably due mainly to the larger exposure to overseas migration as a source of demand. They've also got greater exposure to downturn in foreign students. We'd already had sort of stretched housing affordability and the rental yields were low. So, and they're likely to reduce further on the back of rising, you know, rising vacancy rates and lower rents. So, I guess the message is, you know, there is weakness in the property market, but if you have held the property for a long period of time, you are still probably well in front from what you originally paid. In terms of the market from a selling perspective, stock has dropped in terms of listings, down some 35% at the end of April relative to the same time this last year, 43% below the moving average. But I think the thing to remember here as well is that the reduction in advertised stock levels at a time when we do have low demand is another factor that is helping to and potentially will continue to help you know, stabilise the housing values from a more material downturn. If we look at withdrawal rates, so they did give us a little bit of a scare, withdrawal rates. So you can see there that, you know, the peak in withdrawal rates right in the middle of March as the restrictions came in really spiked up well above the 2009 to 2019, so well above the 10-year range, well above the median. This does sort of give us a bit of a counterweight to the previous slide where, you know, listings are down and withdrawal rates are down. But if those properties do start to come onto the market again, you know, that could increase supply, which again might have some more downward pressure on prices. So it is really tricky because you've got all of these different levers. Some things are positive, some things are negative. So it is a very tricky market at the moment. If we have a look at settlements, we can see that, you know, they're well below the decade average. There is a bit of a lag in the data that we do have around settlements. So they might be marginally lower, marginally higher, but they're certainly well below the average and have come substantially off the peak, which you can see, which was late last year. You know, the substantial drop in sales activity and a similar fall in the sort of number of mortgage-related valuation events sort of suggest to us that the market continues to struggle. But, you know, settlements are definitely a factor of those reduced listings and the reduction in, the market auctions that were pulled off at the last minute. So if we look at rents, most of you, or a majority of you on this call are probably renting out your properties, and we can see going all the way back to 2010. The rental rates, with the exception of Perth, with its mining boom and bust, and then was moving back into boom again. But the major capital cities of Melbourne and Brisbane have remained relatively stable. Sydney had a little bit of a bumpy ride in late 17, 18, but then sort of had started to move back. And the thing about the rental market is that it is being really impacted by COVID-19, because traditionally the rental market is used by casual employees, food service workers, arts and recreation people, foreign students. And I mean, those markets have just, employment, in those markets has just, literally dried up. So the traditional rental market in Australia has really been quite negative, because all of those employees are either not working and on JobKeeper, or not working at all. And then if you overlay the reduction in international students as well, it does really indicate that there's going to be a lower demand for rental properties. So, there is plenty of downside risk for housing values. But as I said a little bit earlier, there's any number of different factors, both positive and negative, that will determine, which way the market goes. Some of the numbers that we have talked about and that I will talk about shortly, some of them were taken at the depths of despair, if you want to call it that, or just as when lockdowns were going in. So there was a lot of negativity. That has turned around a little bit. It is a little bit more positive. But I think we do need to be a little bit cautious around some of that positivity. And I'll talk a little bit about that now. So I guess that was kind of a snapshot of where the market currently is, or where it's sort of come from and where it is today. In terms of an outlook for the market, the property market is really a beast that is driven by all sorts of other underlying economic activity within the country. So I guess there's a few things that do drive it. So the first slide that I've got here is the unemployment rate and the forecast scenarios. So the RBA did a lot of work around, an upside baseline and a downside model. And you can see there in the table that I've extracted on the left-hand side that unemployment going into December, or in December, was about 5.2%. And on their baseline model, the RBA is projecting unemployment to be at about 10% in June, still at 9% by the end of the year, and still at 8.5% by June 2021. So again, that speaks to that slide that we just talked about in terms of rents, with the unemployment rate, perhaps being disproportionately represented by those that would otherwise rent. And if that unemployment rate remains relatively high, then demand for rental properties, and ergo, some of the valuations, is going to be impacted. The other thing is that, unemployment also influences people's confidence in whether or not they can borrow money to buy a house to live in. And so with higher unemployment rates, you'll likely get less owner-occupiers coming into the market as well. The business conditions. So the business conditions, are quite negative, and this measure was taken, when probably in March or April. And I'm sure I saw something earlier this morning that might have popped up a little bit, but it's still definitely negative. And so and that is, I guess, reflected a little bit in the projections on the unemployment rate, because if business confidence stays down, then employers are less likely to take on new employees. And again, that has a flow-on effect into the property market. Consumer sentiment. So again, that's at record lows. It's not at record lows. It's at the lows, very similar to where we found ourselves in the 89 to 1992 recession. And what we're seeing, and I haven't got the chart here, I probably should put it on now that I'm thinking about it out loud, is one thing that we will see, which was very prevalent in the GFC, is a massive spike in the savings rate. So you can see there from the ABS survey that any of the stimulus that's come out so far has generally been saved by most households. And so you're not going to see any of that savings. And when we saw it from the GFC, the savings rate really did spike in 2009 and 2010. And it wasn't until probably 2011, 2012 that savings rate really started to come off, as people were happy to spend money on consumables, but B, a lot more confident about their employment position and being able to move into the property market. If we also have a look at some of the direct measures of the property market, you can see here new housing approvals have fallen quite sharply. Continued weakness, as I said earlier, does have both positive and negative effects on house prices. If approvals are down, it does reduce the supply in the market, so that does support prices. But negative, it also can have a bit of a negative effect in that if there isn't supply coming in, it probably means that there's not the demand there. So again, that has the effect of depressing prices. And look, I don't think we should underestimate the positive impact on house prices that migration has on the Australian property market. It has been one of the greatest contributors to the continuing rise in the Australian property market. And at the moment, with our migration paused and a bit of a national conversation around some of these matters, migration, I don't think we should ever underestimate the importance that it does play in supporting the property market. If I move to GDP, so this is again the RBA's baseline scenario, and this probably sort of culminates, or is the culmination slide of all of those different measures that we saw earlier on in the other slides. The penultimate measure, and you can see here that the GDP doesn't really start to move back to the baseline that we were just prior to Christmas in any scenario until the end of sort of 2020, start of 2021, and in fact in their downside scenario, we're still not there well into 2022. So when you put all of those factors together and you think about the unemployment rate, the confidence, GDP, migration, international students, renters, and the industries that have been hardest hit, you end up with a chart that looks a little bit sad. So the blue line is the expectations of house prices, house price growth, over the next period, and you can see that there's been a very sharp dip in the expectation. And if you see the black line at the top, you can see that it has already started to turn almost in the exact same fashion that the expectation did. But I think the other really important thing, and I mean, this goes a little bit to, as I'm sure many of you have read, some of the issues around the forecasting that Treasury did around JobKeeper. you know, we are dealing with an issue and an economic impact that really does have no historical context. So it is very difficult to get a handle on what might happen, because whilst you know, being a good investment advisor that I am, whilst past performance is no indication of future returns, past performance can at least give us a guide as to how things work. But you know, we don't have any roadmap from previous pandemics. The ability of the government to support the economy has been really eclipsed by the scale of the issue, both the health and economic. And we're seeing that now with the discussions around JobKeeper and how long we can continue to maintain that. And even if the economies are opened up again and we're allowed out and about, will people come back? You know, will people go out to shopping centres? Will they go to auctions? Will they go to open houses? I mean, that is really an unknown question. So that's just a bit of a snapshot of the property market and where we stand today. For those of you that own, that do own properties and have renters or have tenants, each of the state governments, under the guise of the, or not under the guise, under the guidelines of the federal program, have all implemented different levels of concessions for owners, particularly around land tax. Now, as I've said there, each state has its own different rules, eligibility and criteria. Of course, they wouldn't want to make it easier, but as a complete aside, we've had a few of our staff in the office say to us, we don't understand why each state has different rules around property. Why can't it all just be the same? And as I point out to them, it's this little pesky document called the Commonwealth of Australia Constitution Act. And more specifically, section 114, which I hadn't read for a while, but I was reassured, certainly by the first part, in that no state may raise, or maintain a naval or military force. So I think that's good for everyone. Even though we've closed our borders, we are not going to be lining up on either side with muskets. But more importantly, nor shall the Commonwealth impose any tax on property of any kind belonging to the state. So if you'd ever wondered why the rates in each state were different, it's because the states have absolute jurisdiction under our constitution. A couple of other points that I'm sure you're all aware of. Evictions have been banned for residential tenancies for 6 months, except in some limited circumstances. And rental increases are also banned for commercial and residential properties for the same period. So I won't dwell too much, and forgive me if you are not from the main capital cities on the East Coast, but because each of the states have got their own real rules and regulations, what I've done here, and there'll be copies of these slides available, along with, you can access this information on our website. But if you're in Queensland, you can see there's a land tax rebate reducing land tax liabilities by 25%. Interestingly, they've got a specific waiver of the 2% land tax foreign surcharge for foreign entities, depending on whether you're a citizen or not, and depending on the state, there are different rules around that. The important thing here to remember, though, is you're eligible for the concessions under all of the different state rules, where you have given 25% or more of rent relief. So you can see that here in the middle slide for Queensland. If I switch across into, where are we, New South Wales, you can see here landlords must reduce the rent of the affected tenant by at least as much as the land tax reduction. And then if I flip down to Victoria, landlord must pass on an amount at least equivalent to the 25% reduction to their tenants. So look, depending on the state, depending on the type of property, all of those things, and your own circumstances, whether you have or haven't given rent concessions, you will need to figure out what is exactly applicable to you. So if you head across to our website, we've got a specific COVID-19 page. And when you jump onto that page, you'll see down here in this bottom right-hand box, land tax relief for landlords, state and territory updates. You can also see residential rent relief, state and territory updates. So we've kept this updated. Some of the states have legislated, some of them are still legislating. And as it comes through, we'll keep this site updated. And if you've got queries specifically, then, of course, reach out to myself or to Justin, because invariably a lot of these are also entwined with your own tax position. So often a general discussion around your residency status, your rental property, whether you're selling, your CGT, main residence, land tax, rent concessions, etc. So with that being said, I will hand back to Gavin.
Thank you, Daniel, and thank you, Justin. So now we've got the Q&A session. So I might keep up with you, Daniel, first of all. We've got a couple of questions around land tax relief. The first one I've got here is the land tax relief available to non-individuals like trusts, companies, super funds? Does it depend on the structure which you hold the property in?
Sorry, forgot to unmute myself. No, as a general rule, the land tax reduction is available to all entities. As I said, the criteria is more around whether you have been required to give a concession. I can see, Justin, you've come off mute. Were you going to make a point? No. Okay, sorry.
You're fine.
Yeah, no. So it's not specific to the entity. It's specific to whether or not you have given a rent reduction.
The next question, also to you, Daniel, is for land tax relief, does it apply if my rental property became vacant during COVID-19 and you're still unable to rent it out?
Yeah, so as a sweeping, this again is where it gets tricky because it's state by state based, as I've said, but as a sweeping statement, as long as the property is still available for rent, that is, you've got it, listed with a real estate agent or it's on Airbnb or however you've been doing it, then yeah, generally you would be eligible for the land tax relief.
And the same goes, Justin, for rental property deductions, which you mentioned before. As long as the property is ready available for rent, that's fine. Is that correct?
That's correct. As Daniel mentioned, you're actively looking for tenants. You've got an agent that's advertising the property. Then all those normal expenses that you're incurring would be deductible.
Justin, we've got a property on the CGT MRE issue. If you have an SMSF that owns a property in Australia while non-resident, so I assume while the member of the SMSF is a non-resident, does the lower CGT rate of 15% apply after the discount if you were to sell that property?
So that's probably a bit of a complex question because there are real issues with self-managed super funds and non-residents holding self-managed super funds. And in most situations, it can be a real have a lot of adverse tax consequences that might be unintended. So I think where we have clients that are becoming non-residents of Australia for tax purposes that do hold a self-managed super fund, I would recommend that you seek proper tax advice because there can be some unintended tax consequences on the value of the assets sitting in with that in that fund.
And obviously, you can't hold your main residence in the self-managed super fund.
Yeah, there are some real tricky rules around self-managed super funds and non-residents. So I think if you find yourself in that situation, then you do need to take a closer look at the structure of that self-managed super fund.
I've got a question here about residency. And as you mentioned, Justin, residency is based on the facts of the situation, can vary from situation to situation. What about if you're a non-resident, well, you're a taxed non-resident, but you maintain private health insurance in Australia? Could this possibly affect your residency status?
I mean, it's one factor to consider, but it's not to say that it's a determining factor. So probably the key factors that we would always look at are accommodation, so family home, where you're permanently living in both in the new location, but also what was your living arrangements before you relocated, and the location of your family members. And that can be that they're really critical factors that have a heavy weighting in the decision. Then there's those other factors that can help strengthen a case. Private health insurance is one. It wouldn't automatically mean that someone resumes being a tax resident.
And another question, obviously we have people from the audience from the Philippines and Korea, and Australia does have DTAs with those countries. Do you have any comments on the tiebreaker tests in those DTAs?
Yeah, I suppose the attractive one of the benefits of living or relocating to a country that Australia has a double tax agreement with is that it does provide an added level of tax protection. The tiebreaker test can often become a very important factor for short-term secondments or situations where an individual might regularly be travelling back to Australia, where under domestic law you might not be able to break tax residency, but you're becoming a resident in a country like the Philippines. We would then look at the tiebreaker tests, and the tiebreaker tests would then allocate residency rights to one country or another. And generally those tests are, the first test is generally where does your permanent home available, where do you have a permanent home available to you? And with the following test being where's your closer personal and economic ties typically. So for those that are unable to break residency under domestic law, the double tax agreement provides an added level of protection.
Just going on to the CGT MRE issue again. So when CPA Australia was trying to lobby for this not to proceed, the response from Treasury was, well, it's quite simple for people to re-establish their residency. Could you comment on how easy it is for someone to re-establish their Australian tax residency?
Yeah, and again, it's not that it's a loaded question, but there's not one size fits all. It really is looking at all those factors to make a clear determination on whether someone has resumed being a tax resident. But historically, the ATO have really looked at individuals and tried to argue that individuals are tax residents of Australia. So, we have lots of clients in countries of low taxing jurisdictions like Hong Kong and Singapore, or in Dubai or Saudi Arabia, where there's 0% tax, and it's a real target area for the ATO to argue someone is a resident. With this new law, this might open up a different situation where the ATO might actually try and argue that someone is a non-resident, because if someone is argued to be a non-resident and has disposed of their family home, then there is a significant amount of tax that would be due to the ATO. So, we would really look at, relinquishing the property that you were living in the host location, and establishing a home back in Australia. So, it'd be very difficult to argue that you've resumed being a tax resident if you've still got a long-term lease in your foreign location, and every time you're back in Australia, you're simply staying in a hotel. So it really is balancing all those facts around living arrangements, where's all your personal belongings located, where's your family located, to then come to a conclusion.
I like you
Gavin, I'd also probably add, Gavin, that I met with the Treasurer and a small group of people probably, I think it's about 2 weeks ago now, and raised this specific issue, that not only was it unfair originally, but notwithstanding that, the property market had moved in such a way that it was now, selling into a very difficult market. And he indicated he was happy to have a discussion offline around perhaps some sort of deferral. And we're still working to try and get a meeting with him. So, I wouldn't be pinning any hopes on that, but perhaps there could be some deferral at some stage.
Yeah, we can hope, but don't pin your hopes on it. I think that's a good point.
Agreed.
What you said, Justin, before was also good in that you should really be seeking professional advice on residency. It is a very complex area and it turns on the facts of each situation. So definitely make sure you seek advice. Just another question around, again to the CGT MRE issue. What about, are there other possible, maybe more complex arrangements which you could look at? For example, if your spouse remains a Australian resident, are there other opportunities which you could look at this point in time?
Yeah, we are aware of a number of our clients that have situations where the main taxpayer is living abroad and is a foreign tax resident, and the spouse is in Australia and remained a tax resident, and they are going through a process. And we have clients that are going through the process of transferring the property to the spouse that's still living in Australia. Obviously, between married couples, there can be an exemption from stamp duty, and obviously each state is slightly different. So that can be an alternative that some couples are looking at, where there is a spouse that's remained in Australia.
And again, I think advice on that is absolutely essential, right? Because you mentioned stamp duty, could trigger stamp duty. And I know that it's specifically excluded from the anti-avoidance provisions in the EM, but it may depend on how you structure your affairs. I'll pass back to Julian. I think I don't have any more questions. I'll pass back to Julian.
Sure, thank you so much. Just looking at the time here, we're close to the end. So I'll just give a big thank you to CPA for their sponsorship of this committee and this event today. And thank you very much to Justin and Daniel from ShineWing. And thank you, Gavin, for moderating the session.